are, we have a recorded deed of trust, we have the original note. That is the answer to their question. If you have the note and deed of trust, their arguments about showing three elements, and I don't quite follow. I'll go back and look perhaps what he's arguing, but that's the answer. He has to answer that, not that I have to answer his. This is what the law is. You have the note, you're entitled to enforce it.
So they've handed you a document that they purport to be the original note.
Right.
This is confusing to me because that document doesn't have any barcodes. This is a true and correct copy, according to David Rekschick, of the note. As you can see right here, there are barcodes. They've been saying the whole time, this one with barcodes is the true and correct copy. Now we're being ambushed with a new note when we've said the whole time, Mr. Lamothe can't tell whether that's his own signature because the copy is so poor. I mean, it's a little frustrating that they're saying the whole time that this is a true and correct copy when it clearly isn't. Part of the business records. There's David Rekschick, who wasn't allowed to testify regarding the business records. He was asked, you know, do your business records, and this is on page 36 of the transcript, I'm just going to paraphrase so I don't have to look it up. On page 36, he's asked, you know, do you keep the records the same for everybody? And the response is, well, we service everybody the same. And Mr. Stafne responded, okay, well, so can I assume that you treat all the customers the same for the purposes of business records? And he was instructed not to answer on the basis of relevance, which that's clear in this case, clearly an issue, whether or not the business records exemption applies. I mean, it's not appropriate for counsel to be using the business records exception when they won't let us depose the guy regarding the business records exception. I mean, they're trying to have their cake and eat it too. Those limited powers of attorney have to be construed strictly, and that comes from the state Supreme Court. Nowhere in the limited power of attorney is there a reference to plaintiff or the trust. There's a Schedule A that's attached to it, but there's no reference to the Schedule A in the body of the document. This isn't a certified copy. We have no idea whether they just slapped this on at the end to make it look right. I mean, SPS and the plaintiff are enormous corporations who could be entering into limited power of attorney agreements for all sorts of different business transactions that have nothing to do with defendant's loan.
Well, you see, Your Honor, here it is right here. We can foreclose. We've got an original note. But wait a minute, Your Honor. That's not an original note. They had a different original note at the deposition. But you know what? I guess it just doesn't matter in the end, because in this particular case, which went against the Stafne Law Firm, the judge did not issue any particular rationale. Now that stands in stark contrast to the two cases that I've seen with Stafne Law Firm where they did prevail. You can see it right there, where the judges issued specific findings of fact and conclusions of law, either in the open court or in an open letter that's published on the internet. Interesting, isn't it? So anyway, the cast portions of this are the quick and dirty highlights of last Friday's summary judgment hearing involving SPS. And then when we go to color, that will be the straightforward video. Thank you.
I'm not seeing how that fact that MERS is nominee for Liberty Financial Group is creating an issue about who the holder of the note is.
Well, they say MERS is holding the note as of 2008. In order to comply with the PSA, it had to be in the trust by March 22nd, 2006. We're just challenging it insofar as whether or not the plaintiff has standing to bring their case. They, at this point, in 2008, well after the cutoff period, somebody else is saying, hey, Blair Lamothe, I own your note. So it makes perfect sense for in 2009 when he's saying, I'm not sure who owns the note, because he's had so far the trust on one hand tell him they own the note, and he's also had MERS and Liberty tell him they own the note. He has no idea what's going on.
Commercial paper is self-authenticating under ER 902 little I, commercial paper.
The Supreme Court's interpreted this contract and said, when MERS is the beneficiary, even if it's named as the nominee, that doesn't give rise to an agency relationship, so you still have a problem where one party's owning the deed of trust and another party's owning the note, and they're not unified. I mean, plaintiff might be attempting to unify these later against Mr. Lamothe, but that's not appropriate. If they were split in the beginning, they can't be reunited against him. Into court to invoke that court's equitable power to foreclose, they had to they had to have a sum certain, and they had to agree to they had to follow, the condition precedents in the deed of trust. They didn't do that. They're not entitled to foreclose.
Okay. Well, I'll grant summary judgment to U.S. Bank. They should credit Mr. Lamar with the payment he made as of the date that the action was filed. But I don't think that there's any real opposition that amounts to substance here to U.S. Bank's position.
We are.
So we're here on U.S. Bank versus Lamont. I'm not sure how.
Lamont, Your Honor.
Lamont, okay. And preliminarily, I'll deny the CR 56F motion to strike. While I do think that a number of Mr. Glauny's objections were improper in terms of being speaking objections and things designed to communicate improperly with the witness, it all doesn't really matter because it relates to things that are not properly before the court. I mean, this lawsuit is over the foreclosure of a particular note on a particular piece of property. The kinds of things that Mr. Stafne seemed to want to deal with in this deposition would be the kinds of things that would be proper if he were acting on behalf of the Department of Justice or the U.S. or a prosecuting or Attorney General making Consumer Protection Act action against SPS or something or other. And there may very well be reason to investigate SPS, but that's not what's before us at the moment. What's before us here is the particular transaction that we're involved in. And I don't think that the things that they're seeking in that deposition are going to make any difference in the outcome here. That said, I'm a little perplexed about what to do with this case because it's one of the very difficult kinds of situations that I get in which I have a complicated legal argument being made by one or both sides, and the other side's response is essentially to say, that's ridiculous, and go make their own argument. And so then they don't have an engagement between the two sides on the arguments involved, and it becomes very difficult for me to figure out what's going on because I'm not quite sure what to make of the that's ridiculous argument. It appears to me that the statutes clearly provide that the beneficiary of the deed of trust can judicially foreclose on the obligation. Mr. Lamont then proceeds to make an argument that there are three criteria to determine what constitutes an entity to be a beneficiary of the deed of trust for purposes of such a foreclosure. He doesn't have direct authority for that, but he cites a couple of Court of Appeals cases that may support that. And he says there's three different criteria here. Now, I didn't see that U.S. Bank ever responded to that. And maybe I just missed it in the welter of material I got because people were dumping these, stacks of paper on the desk, and I didn't have a chance to necessarily get through every last bit of it all. But it seems to me that that's at the heart of what's really going on here is whether U.S. Bank meets the statutory definition of beneficiary. The Supreme Court in Bain made it clear that there's a requirement that regardless of what the parties enter into in terms of the contractual relationships they do, you have to meet the appropriate statutory definitions in order to avail yourself of the remedies that are provided either under the Deed of Trust Act or under traditional mortgage foreclosure. So if U.S. Bank is going to foreclose as a beneficiary, then it needs to be able to show as a beneficiary, presumably back when this lawsuit was filed in March of 2013 and up through today in order to be able to so foreclose. And I'm not quite clear on where we are on that. So I guess I'd be probably first inclined to hear from Mr. Glauny about his thoughts about that, and then I'll get into what the plaintiff has to say about it. So Mr. Glauny.
Thank you, Your Honor. John Clowney on behalf of the moving party and the plaintiff in this case. Just a word on the CR 56. I sort of regret that I did not simply suspend the deposition and instead of instructing him not to answer and objecting. But I thank the court for the ruling, and I think in the future when I approach that, I will probably simply suspend as the rule permits me. It will simply follow the rules more closely. So thank you. I think, or at least I thought I addressed their argument in this manner, although I will go back and look at it here. But we hold the original note. And to me, in these kind of cases, that is the key. Bain was dealing with the non-judicial foreclosure statute. So whether or not MERS could be a proper beneficiary under that statute was principally before that. We're now here judicially. And the commercial law has been around for a few hundred years on this. We hold the original note, and as I told the counsel, I would walk...
You're looking for the original note. Okay.
As he says it, he starts looking around.
Yeah.
So I'm happy to hand up the original note. You can see that it has Mr. Lamaw's signature. It has the allonge attached, showing the assignment of liberty.
You've shown it to Mr. Fisher. You want to take a look at it, Mr. Fisher?
Invited them to look at it.
Okay.
Now, the reason that's important is because what the law says is that he who holds the original note is the guy who gets to enforce it. And all you have to do is be the holder, particularly when you have it signed in blank. So you have an endorsement in blank, it becomes bearer instrument. So the guy holding that note is the guy who gets to enforce it. The plaintiff here is holding the note through its agents because it's a trust, but it's holding the note. Therefore, it has the right to enforce it. Bearer paper was sort of you might think of it in older terms as sort of an original attempt to create some liquidity in the commercial world. You could transfer this debt around and somebody else could enforce it. But the very point was, if you had the original note, you could enforce it and nobody else could. So if you bring it and you have it in court, that proves that you have the right to enforce it. The second rule that follows that in Washington is that when you have a deed of trust associated with it, as you do here, by operation of law, not by assignments, but by operation of law, that deed of trust follows that note. You don't have to assign it, you don't have to do anything. They go as a bundle. That's other states and some of the authority they rely on, go back to Massachusetts, you have a different rule. That's why that authority isn't very good here in the state of Washington. But in the state of Washington, the note follows, or the deed of trust follows the note. So here we are, we have a recorded deed of trust, we have the original note. That is the answer to their question. If you have the note and deed of trust, their arguments about showing three elements, I don't quite follow. I'll go back and look perhaps while he's arguing, but that's the answer. He has to answer that, not that I have to answer his. This is what the law is. You have the note, you're entitled to enforce it. So they lack any evidence contrary to that. If you notice, I think if you look at their case here, establishing payment or non-payment in these kind of cases is sort of simple and direct. He knows whether he's made payment. This is not an issue outside his personal knowledge. It's not some event that occurred someplace else that he doesn't know about. If he's made payment, he knows it. If he hasn't made payment, he knows it. What did he tell the court? He complained about one payment. He says, well, I stopped making payments in June of 2009. It's because I was confused, wasn't sure who to pay. Then I made one payment in November. And his complaint is, well, that one payment you didn't credit correctly. Because you put it in a suspense account, and the amount's different. The payment's about $8,700, the amount in the suspense account is 60-something, 6,500 or something. Well, I don't think it takes a lot of reasoning to say, when you stop making payments, the default interest kicked in for 4 or 5 months. So when the payment came in, applied to default interest, and then according to the deed of trust, well, you can't make, you have an incomplete payment here. They cited this themselves. You have an incomplete payment, we only make full payments. That's what we agreed to, so we put that in a suspense account. Before we foreclose, we'll apply it. But that's the only complaint he's made.
I understand that. The thing that does concern me about what they're arguing now is that they've cited law indicating that the debtor makes payment to the wrong person at his peril, and that then creates concern when you have an arrangement like this where folks are passing the stuff around from one place to another. I mean, you know, go back 40 years, you know, you simply, you know, I could go to Rainier Bank, to use an appropriately outdated example, get a loan on some, on a house, give a deed of trust to a Pioneer Title, and I would know that Rainier Bank is the people I gotta pay, and they got the note, and I don't have any things. Now, once we start passing stuff around, then we got the problem of, okay, how do you know who it is you pay? And so I'm a little concerned about whether it's appropriate to say when, you know, under the facts here where it's been conveyed, Thornburg appears to be in bankruptcy or in financial difficulties, it's not clear who they ought to pay, whether it's appropriate to just to do what U.S. Bank is asking, which is outright say, okay, you have it can be foreclosed, or whether it's appropriate to say it can be foreclosed, but prior to that, U.S. Bank needs to give Mr. Lamothe the opportunity to bring it current, which would be pay past due payments and interest, but not penalties or attorney's fees or anything else, because who the heck knew until we actually produced the note that this is the right person to pay, and therefore, and so in other words, it seems to me that perhaps the appropriate thing here is to give Mr. Lamothe the opportunity to reinstate if he wants to do so by paying up what should have been paid in times past.
And I think I suggest that in a negative way in my briefing, which is the point of having the original note is that tells you don't have a risk of double payment.
Right.
No one else is claiming. But think of the evidence or the evidence that's not in front of this court. Mr. Lamothe paid from about 2005 when October 2005 through 2009, I guess. He hasn't paid except for one payment since 2009. No other party has come and said, Mr. Lamothe, I'm holding a note, please pay me. There's no evidence here that some other party has made demand on him. The only party who's made demand on him is my client. He's never said, oh, yes, I was confused, I didn't know, but I've been faithfully putting that check every month into an account so I can pay you, and it'd only be fair if you let me pay without any penalties because that was your fault. That's not their position here. He's not come forward and said, now that I know, Judge, yeah, I want to pay. It's not the defense here. No claim that any other parties said demanded. I mean, there's a suggestion from them from a partial reconveyance that maybe Liberty somehow still has this note. Well, Liberty was the original lender. Has Liberty from October 2005 to we're now here in August of 2014, has Liberty come to them at any time in 10 years and said, hey, I got the note, can you please make payments? They made payments for 5 years to somebody else, and yet no other party has ever come forward. It can't be just an ephemeral concern that, gosh, somebody might else want. And that's all you have. You have to put on some actual evidence. The issue over Thornburg, I understand maybe it would be a little confusing. I'm not too persuaded by that, but maybe from my perspective as being a lawyer, I'm not a layperson. But Thornburg sold the servicing rights, not the mortgage, not the note and mortgage. They had the servicing rights to that. Note and mortgage have been held by my client throughout. No contrary evidence of any merit that I can see. So selling it, transferring of the servicing rights doesn't change who holds it, who's the owner of the note, and who holds the note in deed of trust. So we're at summary judgment now. There's a lack of any evidence to support those sort of theories. And maybe in concept you can have those theories. But again, we're down to a specific note and specific obligation to pay. So when he doesn't say, I dispute in any way your calculations of what's owed, except for one payment, which we discussed. And when he doesn't say, gosh, I'll pay now, or I wanted to pay, the point of this system isn't to make it so difficult for lenders to collect. They've given consideration. They gave him $1.5 million, the original lender. They've performed. His only performance, really, is I'll pay you back every month. Since October of 2010, he's not paid a penny to anybody. his performance is and he can explain it. If he thinks, hey, I made all those payments, you just didn't record them correctly, that's within his personal knowledge. And this squabble over the business records really doesn't make any sense in one sense, because the event that you're recording is his action. He can defend that. He can say, yeah, I made all those payments. You just screwed up. Here's my checks. Here's my bank account. He put in a bank statement that showed the one payment, the one that he contested. Then he put a bank statement showing the rest. But at summary judgment, you just can't make these sort of conjectural, it could be SPS is a bad party, or there's mortgage predatory lenders kind of generally in the air. You have to come in and prove this case with evidence here. So should the court, I'm not troubled if the court says, look, maybe he wants to reinstate, but they haven't made that proposition. And that maybe the court could do that if that was their proposition to the court. But I'm waiting to hear that, and then we can maybe discuss how long that would be. But I don't think that's where they're at. They simply haven't put on any evidence to defend the claim.
So just so I understand, your client got the note directly from Liberty Financial? Was it
without getting into the complications, that they transfer. What happens often when they securitize these obligations is that original lender makes it. They transfer it to a party who's forming these trusts. That party transfers it into the trust. The point of making it bearer paper is to avoid the type of arguments that you see where they say, well, you need to show me each step of the way. Bearer paper is a long established commercial way of avoiding that. If you've got the paper, you don't have to show all the intermediary steps to get there.
But obviously the downside of bearer paper is if you walk out of the courthouse and somebody gets you over the head and takes it away from you, then they've got it.
Then they've got it. But then there's, then there are arguments, so you can deal with that. But when you're just down to this point, a debtor who hasn't made the payments, hasn't tried to tell the court he's made the payments, has perfect, complete ability to tell the court if he has made the payments, hasn't really challenged us. He says, well, I'm not sure that's my signature. That's not a challenge. I mean, what you need to come in and say it's not my signature and bring me some, again, you have to prove it. You have to put some evidence in, not just sort of conjecture that, well, maybe I don't think it is. That's not evidence in front of the court. And it really shouldn't be. Lenders who aren't paid should be able to enforce those. This was not supposed to be a complicated system. We give you the money, you pay it every month. If you don't pay it, and there's no excuse that's sort of tangible and real, then we're entitled to our remedy. We're not supposed to turn it into, I've got 2 thick notebooks full with lots of allegations and assertions against SPS and mortgage lenders and such, but none of that gets to whether or not Mr. Lamont has a defense, or did something, or has some defense here. None of that gets there. So we need to try this case, not some other case. They put in an expert witness. Well, you don't need an expert witness for this, not on the subject he's got. They didn't add anything. There's no question that requires expert testimony. Original note, deed of trust, no payment, equals enforcement. So other than this sort of confusion argument, which, for the purpose of summary judgment, I would say, okay, but now he knows. So now he can come up and say, well, here, I want to pay now. Now I know, I'm sure, didn't know there for a while, but now I'm sure that's not the argument he's making. So, happy to address other points that the court has then, but...
So, Mr. Fisher?
Thank you, Your Honor. And my name is Brian Fisher. I'm here for the defendant, Blair Moth. I just want to go back to your earlier ruling on the 56F motion to strike. You mentioned the instructor, or his comments you didn't find objectionable. I was wondering about the instructions not to answer based on relevance, whether those factored in.
Well, I agree that he's not supposed to instruct a witness not to answer on the basis of relevance. But I also agree that it doesn't have any bearing on the outcome of this lawsuit. And so, therefore, 56F is a basis for continuing a summary judgment if you have a reasonable basis to believe that you're going to be able to obtain evidence through discovery that's going to bear on this court's ruling on summary judgment. But I don't see how any of the questions that you were seeking to ask in that deposition were going to have any bearing on the outcome of this summary judgment.
Okay. Just to preserve the record, we did make those arguments in our reply in support of the 56F, and we also submitted an offer of proof saying what we would have gotten.
Right.
I just want to clarify for the record. they've handed you a document that they purport to be the original note.
Right.
This is confusing to me because that document doesn't have any barcodes. This is a true and correct copy, according to David Rekschick, of the note. As you can see right here, there are barcodes. They've been saying the whole time, this one with barcodes is the true and correct copy. Now we're being ambushed with a new note when we've said the whole time, Mr. Lamothe can't tell whether that's his own signature because the copy is so poor. I mean, it's a little frustrating that they're saying the whole time that this is a true and correct copy when it clearly isn't. And I can hand this up to you if you like for the...
No, I mean,
Okay.
I've seen what you submitted, and it does have barcodes on it, but I'm not sure that is necessarily an explanation for what's going on here.
The problem is they have under the evidence rules, they have to authenticate this note that they purport is the original thing. The original note signed in 2005. The only evidence they've put in regarding this is that the note was executed in October of 2005, and then magically 9 years later in 2014, it showed up in plaintiff counsel's office.
Well, but Mr. Fisher, if you really had concerns that the original note that they have is in fact the correct one, what you should have done is either agreed with counsel, or if counsel wouldn't agree, get an order from the court authorizing you to go to counsel's office or to some neutral place where you produce the original note. You can have the experts examine it, you can have handwriting expert people who are expert in ink and paper and everything else, go through it and determine whether in fact it's valid or not. But if you don't do that, then all you've got is wild supposition. You don't have anything that's actual evidence that suggests that that's not in fact the actual note. I mean, on its face, it appears to be the actual note. You know, if you really think that there's problems with it, then you get the experts to look at it and determine whether it's real or not.
Your Honor, that's not how the authentication rules work. The authentication rules require the proponent of the evidence, not the opponent, to authenticate it. It's their responsibility to show that it's the real note. And further, they cite to the law regarding bearer paper. When that goes out the window when you're contesting whether his signature is valid or not. I mean, Mr. Lamothe shouldn't be forced to prove plaintiff's case for them. It's their responsibility to authenticate the note.
Mr. Lamothe, in his declaration, does not say, that's not my signature. He says, I'm not sure whether that's my signature because of the thing. That doesn't create a genuine issue of material fact unless you, if he had actually said, that's not my signature, then I think at that point, then probably U.S. Bank would have to do more in order to demonstrate that they had reason to believe that it was. But, that hasn't been created as a genuine issue of material fact at this point.
Well, I want to go on to the next point, that there's not, the plaintiff is arguing that no one has ever come forward and argued that they actually hold the note since 2005 when Mr. Lamothe, when the note was executed. I have here a certified copy of the deed of partial reconveyance that was filed. Here, let me show you this to you.
I've seen that.
Okay, so would you please pass that forward? So that is admissible pursuant to Evidence Rule 803.14. It's authorized to be recorded by RCW 61-16010, and that's a certified copy from the King County Recorder's Office, so it's admissible under the rule. Now, if you look on the second page, it identifies that the undersigned is the current holder of the note. That's dated in 2008. According to the trust's own documents, that note and deed of trust had to be in the trust by March 22nd, 2006. I mean, we've created an issue where they haven't been able to explain it. They just dismiss this as, oh, it's inadmissible hearsay, whatever. But it is admissible under the rules, and this is at least some evidence that somebody else is claiming to own the note, not the trust.
Here, the person who's claiming to own the note, isn't this MERS as nominee for Liberty Financial Group?
Correct, and plaintiff is nowhere in that.
Well, but Liberty Financial Group obviously was the original holder of the note, and then I assume it went through a number of different transitions, but I'm not seeing how the fact that MERS as nominee for Liberty Financial Group is creating an issue about who the holder of the note is.
Well, they say MERS is holding the note as of 2008. In order to comply with the PSA, it had to be in the trust by March 22nd, 2006. Argument, not challenging an assignment argument, which there have been a lot of Washington courts finding that a borrower doesn't have standing to challenge an assignment of a deed of trust or note. But here, we're not challenging that assignment. We're just challenging it insofar as whether or not the plaintiff has standing to bring their case. They, at this point, in 2008, well after the cutoff period, somebody else is saying, hey, Blair Lamoth, I own your note. So it makes perfect sense for in 2009 when he's saying, I'm not sure who owns the note, because he's had so far the trust on one hand tell him they own the note, and he's also had MERS and Liberty tell him they own the note. He has no idea what's going on. So I also just want to get into just kind of the evidentiary issues in this case, because there are many. We've already gone over the authenticity of the note, but they're also trying to get in the notice of default. That contains nothing but legal conclusions. It doesn't matter whether SPS thought he was in default. It matters whether this court determines that he was in default. That shouldn't be admitted because it's full of nothing but legal conclusions. And the business record exception is not meant to just skirt the rules and be able to get as many legal conclusions in as you want. I would also...
Well, it's certainly ultimately up to the court in a mortgage foreclosure action to determine whether somebody is in default. Certainly the beneficiary or the lender is entitled to assert that they believe that he's in default and file a notice to that effect and ask the court to make the determination that he is in fact in default.
Certainly, but that's not what they filed. They're trying to get that in under a business... to be fair, they didn't say how they're getting it in. They just submitted it under the 904, which I will represent to you. The document, or the letter is nothing like the items listed in 904A1 through 5. They try to get it in under 904A6, but under the principle of edge sum generis, that general that general item that follows a list has to match up with the items in the list. I mean, they haven't authenticated this. There's nobody saying, yes, this is part of the business records. There's David Rekschick, who wasn't allowed to testify regarding the business records. He was asked, do your business records, and this is on page 36 of the transcript, I'm just going to paraphrase so I don't have to look it up. On page 36, he's asked, do you keep the records the same for everybody? And the response is, well, we service everybody the same. And Mr. Stafne responded, okay, well, so can I assume that you treat all the customers the same for the purposes of business records? And he was instructed not to answer on the basis of relevance, which that's clear in this case, clearly an issue, whether or not the business records exemption applies. I mean, it's not appropriate for counsel to be using the business records exception when they won't let us depose the guy regarding the business records exception. I mean, they're trying to have their cake and eat it too. It doesn't make sense. Their argument is basically, this doesn't comply with my theory of the case, get out of here. But the business records exemption is completely an issue here. And I also just want to move on to the limited power of attorney. Now, under Bryant v. Bryant, the state Supreme Court case, those limited powers of attorney have to be construed strictly, and that comes from the state Supreme Court. Nowhere in the limited power of attorney is there a reference to plaintiff or the trust. There's a Schedule A that's attached to it, but there's no reference to the Schedule A in the body of the document. This isn't a certified copy. We have no idea whether they just slapped this on at the end to make it look right. I mean, SPS and the plaintiff are enormous corporations who could be entering into limited power of attorney agreements for all sorts of different business transactions that have nothing to do with defendant's loan. They need to show, before we can allow the declaration of David Rekschick to come in, they have to show that this actually applies to to defendant's loan. Furthermore, it's not a public record because they haven't submitted a certified copy. And under RCW 44040, they're required to submit a certified copy from the Office of the Recorder of Salt Lake County, Utah. Furthermore, the payoff, they're just trying to show you a screenshot and say, this is what we're owed. There's no explanation of the mode of preparation, which is required under RCW 545020. They cite a bunch of cases saying, oh, that doesn't matter. All of them use federal standards, which in the federal exception, or the federal business record exception, does not require any testimony regarding the mode of preparation. I mean, Washington law is clear. You have to either be the custodian or have created or supervised the creation of the business record. The cases they cite, including State v. Ben Neff, even hold that. In Ben Neff, the issue was whether or not the defendant contested bank records, and the qualified witness was the customer service representative who entered everything into the computer, and then later came in and was the qualifying witness. And the court said, well, it's okay if you don't know exactly how it works once it gets into the computer, as long as you made the record and you were the one typing it. I mean, in State v. Smith, the court says clearly, you have to either be the custodian or supervise the creation of the record for it to come in. By Mr. Rekshick's own admission, he did none of those things. He doesn't even know who the custodian is. I mean, that's the real problem in this case. We have this note appearing out of nowhere and no testimony from any custodian saying, here, I'm the custodian, this is the true and real note. Plaintiff's counsel can't be a material witness in here. I mean, there's this issue of authentication all over the board. The payoff, they're just trying to just shove this in under the business records without authenticating this is what it is. They're required to do so. Oh, and one last thing, I also wanted to note for the record, we do object to judgment motion. I will represent to you that we also did it, and I think that was also a mistake. And I think you should strike both the supplemental declaration of Scott Stafne and the supplemental declaration of David Rekshick. Finally, the declaration of David Rekshick has been controverted by plaintiff. In the declaration, he says, sorry about that. He says, first off, that he attached a true and correct copy of the notes, which we know isn't the correct copy because the true copy doesn't have these barcodes. Furthermore, and under paragraph 4, Mr. Rekshick states, in addition, Lamothe failed to make his monthly payment due on July 1st, 2009, and has made no payments on the note and deed of trust since that date, or for more than almost 5 years. Plaintiff just admitted to you that he paid in November of 2009. This guy doesn't know these records. He's a hired guy to just testify whatever they tell him to testify. And I would also point you to their reply, page 3, footnote 7, admits that payment was made November 9. Plaintiff's attempt to explain what happened to that isn't sufficient because, again, he can't be a material witness, and there's been no citation to any declaration or any facts or evidence to explain what's gone on with that November 9th payment. So, and that's a big deal here, because they were required under the provision 2, or excuse me, paragraph 2 of the Uniform Covenant section of the Deed of Trust, they were required to give, or to credit that back to him before initiating foreclosure, which I would represent to you is that is when you file the suit. It doesn't make sense to wait until right before the judicial sale, because they need to give you a sum certain so you know what the judgment needs to be. To put that on there, if they're going to wait till the last minute to credit that, then Mr. Lamothe is going to be stuck paying for all of this interest on the principal balance accruing from the beginning of this suit, which was in March of 2013, I believe, to now. Well, that's not really fair, is it? I mean, they were required before they started the foreclosure process, i.e. suing him on the note and bringing us into court to invoke that court's equitable power to foreclose. They had to give you, they had to have a sum certain, and they had to agree to they had to follow, the condition precedents in the deed of trust. They didn't do that. They're not entitled to foreclose. Oh, I also want to touch on our statute of frauds argument. It seemed that there was a little bit of confusion, so I'd like to use this time to kind of clear that up. So, RCW 6404-010 requires that encumbrances or conveyances of land be by deed, meaning it needs to be in a writing. Under Smith v. Twahi, you can't admit parole evidence to establish an essential portion of the alleged agreement. In the deed of trust, MERS is named as the beneficiary. They point to boilerplate language buried in the body of the deed of trust, but they ignore the fact that in the definition section of the deed of trust, under subsection E, it's bolded, MERS is the beneficiary. And I have a certified copy right here. If you look to page, I think it's 2, there are the beneficiary of the agreement. Do you see this, or are you good?
No, I'm aware.
So under Bain, that's not appropriate. Bain specifically says, and they analyzed the deed of trust just like this one. It was a MERS boilerplate deed of trust, the same one they use in all of their cases, that MERS can't be the beneficiary because as a matter of its business policy, it never holds the note. So they were never.
It names both MERS and Liberty Financial. It's true it puts MERS first, but it does have Liberty Financial in there too.
Well, it names MERS as a nominee. In Bain, the court specifically rejected MERS' argument that, well, we're a nominee, we're an agent. Being a nominee does not give rise automatically to you being an agent. I mean, that's what Bain says. They can't controvert the Supreme Court because they're mad about what the deed of trust says. The Supreme Court's interpreted this contract and said, when MERS is the beneficiary, even if it's named as the nominee, that doesn't give rise to an agency relationship, so you still have a problem where one party's owning the deed of trust and another party's owning the note, and they're not unified. I mean, plaintiff might be attempting to unify these later against Mr. Lamont, but that's not appropriate. If they were split in the beginning, they can't be reunited against him.
Why can they not? I mean, that's the nature of a mortgage arrangement as opposed to a deed of trust arrangement, is that the security and the note are united in one person. That's where, in the old-fashioned mortgage, you simply got money from somebody and you gave them a mortgage on the property as a means of enforcing it. If you were to put the deed of trust and the note together in the same person, you in essence created an old-fashioned mortgage relationship rather than a third-party or a three-party deed of trust arrangement.
I disagree with that. I think if you name a void party as beneficiary, and the Supreme Court in Bain said MERS can't be the beneficiary even if they're named the nominee, then you have a void deed of trust. It doesn't matter if you later unite the void deed of trust with the note. And furthermore, it shouldn't be.
They didn't say that it was a void deed of trust. They said that MERS was not a proper beneficiary of such a thing. But they specifically declined to go on to say what happened in the individual cases before them in Bain because they didn't have enough facts in order to be able to figure out what was going to happen.
But they did hold that just the nominee language alone does not give rise to an agency relationship. There's been nothing introduced saying that MERS in fact was an agent of Liberty. They're basically just asking you to read nominee as agent. That's not appropriate. They have a burden of proof here, and they're not satisfying it. Oh, and then one last point on that standing. On the plaintiff's own website, they say they have nothing to do with foreclosures. They don't, it's all not handled by them. Yet here they are coming in and saying, yes, we have standing. Yes, we're here to foreclose. I mean, this coupled with the issues with the PSA requiring the note be in there by March 22nd, 2006, really raises the question about whether they have standing at all. They want you to just assume they do because they have a document they purport to be the original note, which they haven't authenticated, and we still don't know whether that's the real one or not. That's not appropriate. It's their burden to meet their burden of proof and to show all the evidence they're submitting is what it actually says it is. And with that, I think I'll reserve time for any questions you have.
Okay, no, I don't think so. Is there anything else you want to say about this, Mr. Clowney?
Just a couple of points, Your Honor. One, commercial paper is self-authenticating under ER 902 little I, commercial paper and related documents. And contract language is, as the court I'm sure well knows, is not hearsay. The legal act itself, I'm blanking on the phrase we use for it, but the legal act itself is not.
Well, it's operative language.
Its operative language is not hearsay. So you have that here. We have the original note. I understand his argument about the partial reconveyance, but the question is, do we have it now? We have it now, so we're entitled to foreclose now. So whatever they think about that, whatever they think they may have raised about the past, doesn't create any factual issue here. The argument about the standing and it had to be in the trust and all that, the case law, and I probably only cited a portion of it, all the cases have just simply rejected that argument. And they've done it on a variety of theories. One is, if there's no real risk of double payment, you don't get to go kind of search through the records and try to find some flaw or something, because your obligation is to pay the obligation. That doesn't affect that up. It doesn't affect your obligation to make the payment on the note, something back up a chain of title. So you don't get to attack the pooling and service agreements. You don't get to attack the prior assignments and kind of pick through them and try to nitpick them here or there. The courts are very clear on that. There's no injury in fact. If there's some problem back there, you're not a third-party beneficiary, you have no standing. There's no risk of double payment because, particularly in cases where you have the actual original note in court. So none of those arguments can affect what's going on here. You've got a pretty straightforward case here, Judge. You really do. We have the original note. He hasn't paid. He's complaining about one payment. The court can do what it wants with the one payment, but he's almost $500,000 in default. So, and the statutes or the parties' contract simply says before foreclosure you're going to credit it. The court wants to credit it as of the date we filed. It's not going to make a big difference in this case to eliminate an issue for summary judgment that even concerns the court at all. But I haven't seen any evidence that he doesn't owe the money, hasn't defaulted, that we don't have the note and we don't have the right. The arguments simply don't add up, and he's got to come forward at summary judgment, which is the value of it, because you actually have to put some evidence in it. And just arguments and speculation and conclusory statements don't make it. So that's what I have, Your Honor.
Okay. Well, I'll grant summary judgment to U.S. Bank. They should credit Mr. Lamar with the payment he made as of the date that the action was filed. But I don't think that there's any real opposition that amounts to substance here to U.S. Bank's position.
Your Honor, I have a form of order granting our motion and simply denying theirs. Which I have to do. Thank you. And does the court want to enter an order on the CR 56 other than what we've done here? If they have an order which maybe we can mark up and make it denied.
We can certainly do that if we want to do that.
I'm good with this. Thank you. Well, this has.
Are you sure? Oh, it looks like it doesn't. Yeah.